One of the most frustrating legal experiences is the process that can follow the death of a close friend or loved one. On top of a sense of grief and loss, the person's assets can be tied up in a confusing and time-consuming web of rules. Thankfully, Delaware has a procedure that can be used to transfer certain assets more quickly, the Small Estate Affidavit. We're eForms, the largest online database of fillable legal forms. In this video, we'll address Delaware's small estate affidavits, including how small estate affidavits work, what sort of estates are eligible, and how to file a small estate affidavit. And if you're looking for more information about Delaware's small estate affidavits, be sure to watch through to the end of this video for a link for more information about the estate's rules and regulations. First, how do small estate affidavits work? In the legal world, a person who has died is called the decedent. The assets a decedent leaves are known as an estate, and the formal process of distributing a decedent's estate is known as probate. As you may have heard, probate can be a trying and complex process. Small estate affidavits are a legal tool that allow people who are eligible to receive things from a decedent's estate to bypass the probate process and get money and other assets in their hands more quickly. However, small estate affidavits are only available for certain kinds of estates. If this process is of interest, you should ask, is the estate eligible for the small estate affidavit process? The small estate affidavit process is only available for decedents who have left behind a small and easy to settle estate. Under Delaware law, the total value of the estate cannot exceed $30,000. It also cannot contain any real property, meaning real estate. If either of these conditions is not met, then the estate doesn't qualify and must go through the traditional probate process. The other thing to consider in terms of eligibility is whether you are allowed to file the affidavit. First, Delaware requires that all filers wait at least 30 days from the death of the decedent. Once this time has passed, the next thing to consider is whether the decedent had a will. If the decedent did have a will, only certain people may file a small estate affidavit: the spouse of the decedent's grandparents and their descendants, legal representatives of these parties, and funeral directors. Things get a bit more complicated if the decedent did not have a will. This is called dying intestate. And there are special Delaware rules for intestate succession. But even if the decedent did not have a will, it's likely that a close family member will be eligible to file a small estate affidavit. So, the estate is eligible. How do you go about filing one? As the 30-day mark draws nearer, you should prepare a list of assets and, if there is a will, to compare your list to it. Then contact the Register of Wills for the county where the decedent resided. The necessary small estate affidavit form is only available here and may be obtained in person or by mail, or you can fill it out and return it in the same way. One tip for Delaware small estates: when you contact the register, be sure to ask whether there have been any petitions filed regarding the estate. If there have, get in touch with the person who filed the petition or their attorney, because the courts can't process both claims at once. Small estate affidavits can be tricky, but you can click here to find more information about Delaware's specific rules. And don't forget to hit that subscribe button to find more videos from eForms about other legal topics.